Hey guys, welcome back. Joe Brunsman, insurance broker to the stars. Today, the latest data breach class action lawsuit numbers are in with some pretty shocking information and what I think MSPs need to know and do with this information. So, two primary parts of this video. One, how I think MSPs should communicate these new risks and developments to your clients, as well as legitimizing the additional controls that many of those clients have been putting off for far too long. Two, what MSP should do with this knowledge internally. And then three, as a bonus, a least likely victim to show you a lot of this information is really, really under the radar, but it's impacting even small organizations. All right. So one, biggest kind of takeaway here is breaches are now more than just tech problems. So the threat landscape has changed. They are now legal problems too. So the days of, oh, I got ransomware, I got to pay the ransom and, deal with, oh, the business interruption, all that, that is gone. There is now a serious legal problem underlying all of this. In 2025, more than 1,800 data breach class action claims were filed, which is more than 150 per month. Now, as you'll see at the very end of this video, the number is likely much larger than that. That is just what is captured on the actual dockets. All right. This is where people are actually fighting these, not where they're just being an SMB and immediately going to settlement because the economics are too potentially crushing to fight it. Now, modest breaches were easy technical solutions. Now could result in years-long litigation risks. So not a fun time to be a small business owner. Now, the average business owner may be saying, hey, you know what? But I paid the ransom. Well, as we saw in the report this year, paying the ransom doesn't guarantee that criminals are going to delete that data, and courts are taking that threat seriously. Now, courts have already found, and this was very interesting, standing. So yes, the case can proceed even when companies paid that ransom and data wasn't confirmed to be published. So now we're taking a step above. We're saying, hey, not only did a company pay the ransom, not only could the company show, hey, nobody could even confirm this data is out there in the world. Well, that doesn't mean that that SMB or that business is going to get out of their class action claim. So clients who think they're paying that ransom, that's the end of the liability story. They are now sadly mistaken. MSPs, I want you to make sure that your clients understand this, that, hey, just paying the ransom and moving on to the next is no longer a viable option for those clients. Clients may also be saying, hey, but nothing bad has happened yet. So why is this happening? Well, courts now are increasingly recognizing that just the risk of future harm is enough to establish standing in these class action claims. Clients whose data was stolen but hasn't been misused can still be sued. All right, so we got that problem. Next, dozens of cases where negligence and implied contracts claims survived motions to dismiss even without confirmed fraud. So this is really a big switch. Kind of what we're seeing here is traditionally there had to be something that an attorney could point to say, hey, these people have been damaged. Now we're saying, well, it's just the potential risk of future harm could be enough here to actually let this class action claim move forward. Now, types of data matters pretty much more than volume. That's really the trend I was seeing in the documentation here. So cases around PII and PHI, so PII being social security numbers, driver's license numbers, PHI being health information, those survive challenges at a far higher rate. Why is that? Well, you can't really change your social. You can't really change your medical history. It is what it is, and the courts are beginning to recognize that. Now, it's not just the amount of data, it's the types of data being held. In addition, kind of an additional risk factor here is failure to identify a breach quickly and notify people means a much higher risk of litigation. So MSPs, I think you can take that information and say, hey, here's why we need additional controls. Here's why we need, better oversight over these systems, because the longer the bad guy's in there, the more likely that this data breach class action will come knocking on your door. Of course, delayed notification creates higher liability. Why? Because now not only do you have attorneys who are very angry, you have clients that are very angry, And of course, regulators get very angry there too. So I didn't put this in there, but you're seeing a lot of parallel construction now between the regulatory bodies as well as the plaintiffs' bar attorneys, just because of the amount of information that's being stolen, the types, as well as the fact that a lot of this is just publicly available. Now, vendor relationships matter. So that vendor that you have with terrible security, looking at you, dental offices, the ones that your MSPs complain about, still looking at you, small dental offices, either A, you need to find a new vendor, or you need to talk to your MSP about serious compensating controls, and if that's even possible. Why does this matter now? You as an SMB might be saying, hey, but it wasn't me that got hit. It was my vendor that got hit, and their security sucked, and there was nothing I could do about it. Well, this particular case, Peralta v. I just put CES, not to put it out there to the world. Well, the CES vendor got hit by the cyber event, but then CES got hit with the lawsuit. Why did this happen? Because essentially the judge, I guess in this case, they let this motion continue because they said, hey, CES failed to adequately vet and monitor its vendors. Therefore, CES contributed to the breach. So if you're out there and you've got bad vendors, if you have vendors with awful cybersecurity controls, MSPs, please talk to your clients about this. I know that internally you guys will complain about this a lot, but you want to make sure that that information is getting to your clients. One, so that you're not held liable for it. And two, so your clients can do something about it or at least weigh that risk against all other available options in their industry. Now, in this case, CES likely paid a settlement. Compliance as a legal defense. So where I see MSPs is where I was, probably 8 years ago now, where you have all this information in your head and you want to go tell the world and it's compliance. And your client tells you, hey, kick rocks. Thanks for the information. I'm not going to do that. It's not in the budget. So I really think that MSPs need to start reframing compliance as a legal defense. I think that's a much better way to do it. So what we saw in the court records here, hey, HIPAA compliance is a minimum standard for care. It is not that, I have met HIPAA high tech, I am good, therefore I have nothing else to do. Nope, that is the minimum standard. So I put this in here. HIPAA compliance doesn't immunize you from lawsuits, but failing to comply is a very strong evidence of negligence. So please start taking HIPAA seriously. Is HHS OCR going to come after you? Hell, I don't know. There's probably like 5 people in that office anymore. Would some data breach class action attorney come after you? Absolutely. Now, FTC. So NIST CSF, in effect, this is the de facto standard of care. So this is now moving forward your reasonable security baseline that courts are going to be looking at. This is what companies are being judged on. The FTC, NIST CSF, it's publicly available. It's supported by the government. It's going to be around there forever. So MSPs, I would say, hey, if you're a CIS type of fellow, or if you're a NIST CSF type of fellow, or a crosswalk type of gal, I don't really know. But what we're seeing in the court records here is it looks like NIST CSF, courtesy of the FTC and their reasonable cybersecurity standards and their publications, that is now creating the de facto standard of care. So these reasonable precaution standards, we're seeing that courts are putting out this kind of reasonable precaution as like a common law duty of care that goes above and beyond, and in some cases kind of parallel to all of these other data security standards out there. So what does that really mean? It means, okay, all these other rules aside, we live in a society and we are going to judge you based upon the type and amount of information you had. And just because you met HIPAA and you did security awareness training once a year, well, you know what? You had 50,000 records of PII. You are not taking reasonable precautions to adequately defend and control that information. So now we're going to hold you negligent. So please be sure that you understand, go talk to your attorney about what these reasonable precautions would look like, because it looks like they're being applied to all different types of sectors that we have never seen before. What does all this mean in a nutshell? It means minimum compliance. And I know a lot of companies are still struggling with just compliance, but we've moved past just compliance. And now we're saying, hey, minimum compliance is no longer enough. You have to be proactive about your cybersecurity, and please document that. Now, internal knowledge for MSPs. What do I want you guys to know here? One, please assess your own risk posture. So review your contracts, your own security practices, your insurance coverage. When we start looking at MSPs being sucked into these data breach class actions, all of your internal policies, procedures, controls, vendor assessments, etc., that could all be on the chopping block as well. They're going to be reviewed, analyzed, and scrutinized. So you need to make sure that your own house is in order there. One really particularly interesting note here, and remember, these are just for data breach class actions that got to the court stage dealing with certifications. It's not even dealing with all the SMBs that, quite frankly, probably just paid for the settlement because they didn't want to deal with this headache. Inside of this, it said, hey, these incident response playbooks and tabletop exercises, one, lower breach costs, and two, were specifically singled out as a better defense in litigation and in regulatory proceedings. So if you're an MSP, if you have the manpower, considering just offering that service for some incident response tabletop exercises with your clients, framing it as more of one, practical, two, obviously useful, but three, potentially aiding in their legal defense. Now, as an MSP, please help your clients. I know 90% of the time they probably don't care. Hopefully with this knowledge, you can motivate them to care, but help your clients with the paperwork trail. So following industry guidelines, implementing those reasonable precautions and reasonable cybersecurity safeguard measures. So yes, that could go well above beyond HIPAA, still looking at you, small dental offices. I think a lot of this really boils down to educating clients. So my non-MSP clients, like my traditional client base, I'll talk to them one-on-one about a lot of this stuff, and I'm just their insurance guy. But I'll say, hey, guys, here's what I'm seeing. So if you're a CPA firm, you're an RIA, something else, I'm going, hey, guys, this is what I'm seeing in the legal world. I want to make sure that you're aware of this. Once we go through that education pathway, they seem to be a lot more receptive, I will say, to their MSPs. So do with that what you will. All right, MSP warning here. Remember, you can get wrapped into this too. So I've already put that in a previous video. Yes, your client can get hit. You get wrapped into that data breach claim. So please plan accordingly. There are a myriad of MSA SOW considerations that go into this and specific language. And at some point I will make, if you guys would like, an entire video. It would be just boring as all get out, where I'm just going to go through and I'm going to say, hey, here's a standard MSA. Here's the general idea of what these clauses are saying and how they are important, kind of given the broad swath of risks that an MSP could face. Next, remember, not every client needs to be your client. Still looking at you, small dental offices. So if you have clients that you are doing everything you can to help them and educate them, and they still just don't care, well, I have a video on that. Actually, I'll post it right above here on how to have those tough conversations and what to do so that you can decide based on your business and your client the best response to try and keep your MSP safe. Finally, and this is something I say ad nauseum, please do not let a client's risk tolerance exceed your own. That is where I see people just getting whacked out of left field, is when they've got a client kind of going rogue. But the MRR is good, and I understand it, but if that client's risk tolerance is exceeding your own, you need to think about offboarding them at the quickest available opportunity in accordance with your MSA. Please don't get in trouble there. Now, if you need help with this video is brought to you by CCA, attorneys for the situation. If you are just looking for MSA, SOW, and some other fun stuff, check out xclause.com. All right, now, certification rates. This is interesting. So this is back in 2024, and you'll see that 40% were granted certification, 60% denied. Now over here, you'll see 2025 rates. This is the latest year we have data for. Obviously, 2026 still ongoing. And you would think, oh, wow, well, it looks like that the certification rates are going down. Doesn't that mean everything you just told me, Joe, is complete psychobabble nonsense? Actually, no, it is not. So there's a reason for that. Let's talk about part 3 here, the bonus part, which is the least likely victim. So 2025, this was a steel lamination company that got hit. Now, if you're an MSP, you're probably thinking of, people in medical, people in finance. Like those are obviously big client bases for you. I have yet to meet an MSP that focuses on steel lamination companies. Nonetheless, they got hit. So what happened? Well, it was about a 24-hour period. Only about 5,000 people's data was accessed. So this is not a big company. It's not in an industry that you as an MSP would typically think of as being particularly high risk. Well, they got hit with a data breach class action claim. Now, in this case, the case never reached certification motion. The parties settled. So what does that mean? Well, within 9 months, these guys got hit, dealt with the event, class action claim, deal with all that, had to settle it. Why? I don't know. It'd be purely speculative. But what that means is if we go back here, it means that that case wouldn't even be reflected in the numbers. So a lot of those SMBs out there, they simply can't or won't fight this because the pure economics are just so brutally overwhelming against them that they're not going to take that risk. They're not even going to get to the point of trying to fight certification. They are just going to settle and bounce. So with that, you got to think, how much did that cyber event cost them to begin with? Now you got to look up all the particulars. You can find it online, the actual settlement facts of this particular case. You start adding that up, that could be a lot of cash. So in that particular case, hey, one, MSP, contractually require your clients, to carry cyber insurance. You are insane if you are not doing that. 2, if you're an SMB watching this, you might need to carry more cyber insurance, even if you're not in an industry that typically kind of falls victim to this stuff. So technology, healthcare, finance, etc. You just see right in front of you here, steel lamination company. They got boned. All right, guys. Hope you enjoyed that. Like, share, comment, subscribe. If you have any questions, leave a comment below. And with that, stay safe.